Hello, Jacqueline Harris here. First and foremost, I would like to thank you for staying subscribed to my video podcast. As you could tell early on, I am taking somewhat of a unique route when it comes to giving you all information in regards to the areas in which you own real estate. And what I'll be doing is just driving through the area personally for myself so I can see what changed and to also keep you all up to date with what's going on in the area visually and with interviews with other industry professionals. Now, in this video, I will be speaking with Anthony Dispoto, Esquire, who is actually a local contract attorney. We'll be going over information in regards to partnership agreements and what to look out for or what to do prior to going into a partnership with other individuals for when acquiring commercial real estate. We'll also be talking about exit strategies as well when you are ready to exit the partnership. And before doing so, I actually want to take you guys on a quick tour around a local building that I have available for lease. The building is located at 12341 Hawthorne Boulevard in Hawthorne, California, currently zoned for retail office space, and we have about 8,600 square feet. A couple of highlights here. We do have excellent visibility, street frontage here, high ceilings internally, roll up door in the rear, high density neighborhood. I do have another video attached to this one showing you all what the building looks like on the inside, and you can also find it on LoopNet, and a link to that will also be attached to this video. Now, without further ado, I would like to introduce you all to Anthony. We'll be talking for about 30 minutes and enjoy the ride as I take you guys around the city from Hawthorne, El Segundo, back into the Los Angeles area. And if you guys have any topics you would like to discuss, feel free to reach out to Anthony or myself. Thank you and enjoy your day. Anthony, I'm actually going to pass the mic to you so you can tell the audience a little bit about yourself and what you do.
Yeah, so my brand is the contracts attorney because I am a contract attorney. Most of what I do happens to fall into transaction based law. I do a lot of documentation, whether it's along the lines of contracts between two different persons, whether they're a business or a customer. I do a lot of real estate transactions, commercial, and I do a little bit of residential, and then I do a lot of entity formation. And so a lot of those blend really well together. And I am capable of serving my clients in many different ways, acting as an outside counsel, acting as just general counseling advice, or helping out with different transactions that they may be going through.
Just give us a little bit of background on partnership agreements and things that you'll want to avoid.
Sure. There's plenty of different ways to structure partnerships. If we're talking specifically about real estate, I think that we're talking two primary ways to structure partnerships. And by partnerships, I'm not speaking in the very um, legal defined sense. I'm speaking as two or more persons joining together to form some sort of common goal. So there's really three different partnership structures total. There's corporations where you have a bunch of different people working together. They tend to hire the directors and officers that manage the business and help guide it along the right tracks to get to where it needs to be. As far as real estate's concerned, we do not use corporations at all. Most of the time, it's because there's an issue called changing control. And when you change out of a corporation or into a corporation, or too many people trade stock within a corporation, uh, it's considered a sale. And so when you're talking about real estate, you're talking about a reassessment issue. And so we never deal with corporations or S corporations as far as partnerships are concerned. So to talk about the two other ones, we're talking about a very pure form of partnership, most of the time a limited partnership, which has a general partner, somebody that's responsible for the day-to-day operations, and a limited partner, which is usually the money person. They stay in the background and they say, here's my $100,000, go get me a return, I'm hands off the wheel, you're responsible. The
Mm-hmm.
other version, which is very common and probably the most common form of partnership ownership, would be the LLC. And now uh, LLC can come in different forms. It could come as a single member LLC, which is technically considered a disregarded entity, doesn't have a different EIN or anything like that. Or you have more than one member in the LLC, and that is commonly taxed under a partnership structure. And the partnership tax code is a completely different thing. I'm not here to talk about taxes. That's not my forte. So I'm not going to deal with that.
Okay.
Um, Now, there's just to like go in a little bit deeper. I don't want to go too far into it, but there's multiple ways for a multi-member LLC to be managed. There's one that's kind of like the GP LP situation where you have a member. Actually, not, you don't have a member, you have a manager that provides the guidance on how the partnership is run, and that would be a manager managed LLC. And then you have another LLC where it's all of the members have an equal say in how the LLC is run, and that would be a member managed LLC. But those are the two most common structures that we encounter as far as real estate deals are concerned.
When it comes to corporations and real estate, can you elaborate a little bit more on why it's a bad idea?
Gotcha. So the benefit of real estate, as I see it, and I think as a lot of people see it, is it's long-term wealth. The longer you hold it, the more benefit you get out of it long term. That's how I foresee it, at least. And so when we're talking about corporations, we're talking about if you hold it in that corporation and the shareholders don't change, and you have everybody join at a really young age, and your plan is to sell it out, transfer at a later point in time, sure, that's a good 20, 30-year strategy. But when you're talking about any aspect of estate planning, passing on anything to the next generation, it can become problematic. And so what I encounter very often is the fact that people want to take the property that they own. Maybe they want to put it into an LLC for liability protection, because if you're the property owner and something happens at your property, a lot of the times you can be held responsible. So LLCs, good insurance, great ways to go about limiting your liability. Now, when you go to transfer it out of your name into an LLC, we are allowed reassessment exemptions because you're not necessarily changing anything about the way it's being held, just the manner in which it's being held. And the tax code is very forgiving in the sense that if the same person, so, if I transfer a property to company A and
Mm-hmm.
I'm 100% owner, the the assessor is not going to look at that any different as if I'm continuing to hold the property. So even if I've held this property for 30 years and I transfer it over to this company, my property taxes are going to be the exact same. So that's where the benefit is. But when you go to change, when you have a corporation and it changes hands, so say I own a corporation and I want to put that corporation under my trust. As soon as I put it under my trust, that's considered a sale. And so when I go to exchange it out to the trust, I'm going to get reassessed, which might not be an issue if you've only held it for a year. But if you've held it for 30 years and you're planning to give this to your kids, your grandkids, you're now talking about probably increasing your property taxes 3, 4, 5 times what they were before and blowing out all that cash flow. So that's where we're talking about the problem. So as far as corporations or S corps, C corps, whatever it is, we don't we don't look at them at all generally. um, for anything like this. Now, there could be very rare exemptions or exceptions, such as you're trying to get institutional funding and they're only going to touch a C Corp. You know, it might be a case, but we really don't see it very often. You have to be pretty much a listed corporation, public corporation to do anything like that.
So, unless you are going public with your corporation on the NASDAQ or the Dow, when it comes to real estate, you want to avoid corporations or forming corporations at all costs. And then we also want to mention that when you have a partnership, and another reason why you want to avoid any type of corporation is because when it comes to estate planning, it definitely is going to lead to issues down the way, issues that could definitely be avoided as long as the contract is put in place appropriately, uh, considering your level of risk on the asset or assets that you currently own and operate. So, Anthony, can we go a little bit deeper into partnerships when it comes to exit strategies? Sometimes, partnerships are held for, 5 years, 10 years, or even longer, depending on how the two or more parties get along. Now, can we talk a little bit more about partnerships and how they could be dissolved with the least amount of risk?
So it all depends on what your preparation is. If you go into a partnership and you have an idea on how you would like it to end, or you at least like to plan for the inevitable, which is the partnership will end, and you put it into your agreement, um, it becomes very easy. Somebody wants to retire, you delineate the options or you enumerate what options they have upon somebody's retirement, and then you follow the plan. It's as easy as one, two, three. Now, if you decide to enter into a partnership and you go based on a verbal agreement, which is still to this day fairly common, it's not. Most people decide that, hey, let's try this. And then as soon as success catches up to them, they get so overwhelmed with maintaining the success that they don't anticipate what happens when this goes wrong, because it's not an if question, it's a when question. So, in a situation where you have no sort of partnership agreement in place that actually spells out what happens when somebody wants to retire, somebody dies, somebody becomes incapacitated, somebody gets divorced, any of these situations, then what you have is whoever becomes the successor now owns the interest. And I was honestly just talking to a property manager earlier today, and he said whenever property switches hands, that's when he always pushes for the sale of the property. Because now, if you have a partnership, I entered into a deal with somebody, but as soon as their children or their grandchildren or their spouse or whoever their successor is gets involved, now I'm dealing with an entirely different party. This isn't the partnership I signed up for. And so, a couple of different ways is you can buy your way out. They're typically going to want fair market value, even though they don't really have an alienable interest. They can't divide it from the partnership itself. So, can you buy half a building? Not really. So, what happens in those situations is they end up fighting. You do have a legal right, which if you own them out of an LLC, you own them just in a partnership, then what you would do is you would file for a partition action. You get attorneys involved, you pay attorneys' fees through the nose, and then all of a sudden you decide, okay, well, I'm going to sell it when I could have just agreed to the first deal in the first place and probably got an extra 20% because of how many attorneys' fees we paid. And when you're talking small business, attorneys are the only one that make money
Hmm.
because we're racking up several $100 an hour fees to complete the deal. So we want as many hours as you're willing to give us. If you want us to fight, I'll fight all day, but it's not to the benefit of your client. So to pay a little bit more up front and to save hundreds of thousands of dollars and heartache and headache in the future is immensely worth it.
So when it comes to contracts, I would say you would want the person to come and see you when it comes to signing the contract or putting the contract together, right?
I That would be the best case scenario, but even then, just put something in writing. It could be a napkin for all it matters. Just have an idea on what you guys or girls want to do when you're exiting and the situations and when you're exiting and put it in writing. Because if you don't put it in writing, it doesn't exist.
So basically, just make sure you have a napkin handy and a pen or a piece of paper available just to write out the general details of the partnership that you guys are entering into when it comes to purchasing real estate with another party or another individual or individuals. Make sure that there is just some level of protection when forming this partnership agreement. If you're up for story time, give us a little bit of an example of what can happen when a partnership agreement is not set in place at the beginning of a deal.
Sure. Um, I have several different stories. I think the first one that comes to mind right now is I had a client that um, his father owns and managed, well, his a group of family members owned a couple of commercial properties together, and the father managed it, and the father unfortunately passed away, and the responsibilities fell onto his son. And when he was doing the work associated with it, the other family members just didn't trust what he was doing. And so what happened was it ended up being it ended up being to the point where the family members sued one another. They put list pendants on properties against one another, and it took probably 3 years of fighting and attorney's fees and heartache and headache to get to a point where they finally came to terms and we finally closed the deal. And this happened 3 weeks ago. They finally closed the deal 3 weeks ago. It could have been so simple. The property manager, as soon as it passed, what he said, as soon as it passed to the hands of the next of kin, you should have sold it. You get a step up in tax basis when that happens, and you could sell at no capital gains. Or you hold it, and if everybody works along, sure, it works out great, but nothing's a problem until it becomes a problem. So everybody starts fighting, they start suing each other. And then after you expend 60, 70, 80 grand in attorney's fees, you come out to an okay resolution. Nobody's necessarily 100% happy with what happens, but at the end of the day, you just want it done. You just want to stop fighting and finish up what needs to be done. And so it's a resolution that I think my client was happy with because it finally finished.
Mhm.
And I think that I gave him a pretty decent deal compared to like another law firm, but it's still not a perfect solution. If somebody had said, hey, when this happens, when somebody dies or passes away, now the other members can buy out 100% of the interest, or we're going to have this person manage it, or ABC. There's so many things that you can articulate and put into a writing about how you would like the next process to go, so there's no fighting.
So again, contract on paper of any sort is very important at the beginning of a contract. Therefore, when the end comes, you guys already have a written agreement in place on how to dissolve the partnership. And so you could actually come to play as a contract attorney at certain levels of the agreement. You could come into play when it comes to drafting the agreement. You also come to play when there is a conflict that arises in the agreement. But can you break down a little bit more where your job begins in creating a relationship with your client and where your job ends?
So in to be honest, my job begins whenever a client wants to bring me in. So it can begin before they even contemplate buying a property with somebody else. It could come in after they've bought the property with somebody else. It could come in after somebody's already started a fight with their partner on the property. It doesn't really matter, but my job is to counsel and advise as to what your rights are, where your standing is, and recommendations on how can we make the situation better, or how can we protect your interest, or anything along the like. And again, it depends. It can even come in to play after they've sold the property, in a situation where they want to 1031 out into something else, and they just want to be advised on where their rights are and what they can do. So it's a very broad spectrum, but most attorneys will have free consults. And so if you need to understand, do I need an attorney? Reach out to one, because for 30 minutes of time, probably 50% of attorneys will say, okay, I'll take the time to speak with you. Real estate deals, in my mind, always preferable. They're good. It's good money. You like who you work with. It's most of the time it's a straightforward transaction, and it's not as heated of a debate as breach of contract, as any sort of litigation. And you can usually find some sort of middle ground because real estate is so flexible and versatile.
Can we backtrack a little bit? I forgot to mention earlier, and it just came to mind again that you mentioned the term less pendants, least pend. I never know how to say it right, but can you elaborate a little bit more on what less pendants is?
A lis pendens is an instrument, and I was talking. I believe this was when I was talking about the two families fighting each other. But essentially, what a lis pendens is it's a recorded notice. Sorry about that. It's a recorded notice that essentially is recorded against a property, and it says this property is in dispute, or there's some aspect of this property in dispute. And the reason for it is there's something in the law called a bonafide purchaser. And so a bonafide purchaser is somebody that buys something in good faith, that has no understanding that there's any sort of dispute revolving around a particular object or property. And if I buy something in good faith without any understanding of that, I would be essentially waived from a lawsuit. If there's three parties involved, there's a buyer, seller, and then there's the bona fide purchaser. Buyer and a seller enter into an agreement. The seller rebukes on the agreement and then sells it over to another party, but doesn't tell that buyer. And then when the buyer comes to buy it at a later point in time or bring a lawsuit against them, they would not necessarily have a good claim, because the law doesn't favor hurting an innocent third party. So all land is considered unique, as far as California and United States law is for the most part. But in that situation, if that other buyer, bona fide purchaser, is no longer a bona fide purchaser, they're aware of that contract between the two people because a lis pendens was filed on the property. That property can't be sold. So in that situation, the seller might try to sell it to a third person. Nobody's going to touch it because there's a lis pendens filed against the property. And when they go to do a title search, it pops up and says, there's a claim against this property, and it prevents that situation from happening altogether.
Okay. All right. Thank you for clearing that up for us, Anthony, because you did a better job of explaining that than I could. Uh, so, concluding this segment of our broadcast, can you just let the audience know what markets you work in, how they can find you?
I work in all of California. I have a lot of phone calls for people in the Bay Area. I'm located in Orange County. But I have people in LA, I have people in Bay Area, Riverside, San Bernardino, San Diego. I work everywhere. My law firm is fully remote, so I just work from home. That's part of my posturing is I provide what I think is fair cost legal services, focused more on service orientation, more than anybody else. And I try and get somebody a deal so they feel like they're not getting, gypped at the end of the day. And that's really what I try to do. I do some deals across state lines. It's not really my forte, but as far as if I represent somebody in California and they own property across state lines, I'm happy to act as a general counsel or of counsel for them in those situations as well.
Well, you do know we have a couple of individuals that are choosing to pursue investments out of California. You know, a couple investors purchasing property in Miami. Definitely, Phoenix is a very hot market right now for investing, and Texas as well. So, when it comes to assisting with contracts, are you able to do work in these markets, or how's your business structured?
It's the way, so as far as transactional work is concerned, the contract itself is really the core document, and I don't have to know extraneous law within that state. I'm licensed in California, and traditionally you do business in the state that you're licensed. But when it comes to contractual obligations, I'm very capable of doing work out of state. It's usually I have to have some nexus with California that will allow me to do work for a particular person.
All right, so that would actually conclude our video for today. Real quick, real simple, touching a lot on the importance of contracts when it comes to partnerships. And I would also like to mention that Anthony and I will be partnering on a regular basis, providing detailed information to you all when it comes to contracts, when it comes to commercial real estate. So, if there are any questions that you all have for us, feel free to reach out to Anthony or myself, and we will definitely do the best to address your questions in our coming podcast. All right. So, once again, my name is Jacqueline Harris. This is Anthony. Anthony, enjoy your day, and we'll talk to you again soon.